Please be advised that this recorded webinar has been edited from its original format, which may have included a product demo. To set up a live demo or to request more information, please complete the form to the right. Or if you are currently not on CSC Global, there is a link to the website in the description of this video. Thank you.
Hello everyone and welcome to today's webinar, The Diligent UCC Search, a how-to guide for the searcher. My name is Annie Triboletti and I will be your moderator. Joining us today is Paul Hodnefield. Paul is the Associate General Counsel for CSC, where he is responsible for advising the company regarding real estate recording, notary, Uniform Commercial Code, and other public record transaction services. And with that, let's welcome Paul.
Thank you, Annie. As Annie mentioned, I'm Associate General Counsel at CSC, and part of my responsibility is to be involved in developments related to the UCC. So with that in mind, I'm an active participant in the industry. I participate with the filing officers in their organization, IACA. I co-chair a task force on filing office operations and search logic for the American Bar Association. I am currently co-chair of a subcommittee of the Uniform Law Commission's review of emerging technologies in the UCC. The subcommittee covers Article 9 system issues. And I monitor case law, I monitor legislation on a daily basis, and I do a lot of troubleshooting with filing offices. So needless to say, I get a lot of information, and much of that is related to search issues. And today I'm going to share some of that information with you. Legal professionals and lenders pay very close attention to every step of the UCC filing process, and with good reason, because even the smallest error carries a substantial amount of risk. But filing is only one side of the coin in the UCC process. The search process can be just as risky, at least for those who have to rely on the results. This program explains what is really required as part of a diligent and reliable search. It will identify a number of potential traps for the unwary searcher and offer suggested best practices to manage the risk inherent in the UCC search process. I'll begin by covering some essential concepts that searchers must understand about the UCC filing system, and then explain the elements of a diligent search. However, conducting a diligent search is only part of the equation. The interested party must also correctly interpret the results. Therefore, I will also explain how to interpret UCC search results, including the effect of UCC 3 amendments, which don't always do what their title implies, and they can be easily misunderstood. At the end, I'll leave a little bit of time for questions. So let's go ahead and begin with the essential concepts behind the UCC system that searchers must always keep in mind when conducting searches. The first, and this is probably the most important thing to remember about the system for the UCC searcher, is that the UCC system is a notice filing system. What that means is that the records that get filed, financing statements, are just notices. These are not liens, they're not operative documents, they're not enforceable documents. They aren't anything that you can go to court and enforce. For example, a secured party cannot enforce a financing statement. They are merely a notice that has to be filed as part of the process, but they are not enforceable in and of themselves. They are merely notices that indicate a security interest may exist. And because they are mere notices, they're very simple records. They provide just the basic information to alert somebody of a potential security interest. And because of that, they don't provide all the details of the transaction. Dollar amounts, terms and conditions, covenants, and things like that. These aren't part of financing statements typically. They're not found in the record. Just the basics are found in the record. And because the details of the transaction are not part of the public record, it's necessary that those involved in the search process, searchers, interested parties, they must look beyond the public record to learn the full state of affairs. Article 9 does not intend that these records provide all the details of the transaction, and it is expected that interested parties will look in other places, primarily to contact the parties involved for more information. And the courts recognize this. I cited a case here, Key Bank versus Huntington Bank, that illustrates this. Key Bank had a blanket security interest on all the debtor's assets and filed a financing statement to perfect. Later, Huntington Bank financed the debtor's acquisition of 3 specific pieces of equipment on a purchase money basis, and they filed a financing statement that described the collateral as simply equipment. When the debtor defaulted, Key Bank argued that Huntington wasn't entitled to purchase money priority because they didn't describe the specific equipment, and therefore Key had no knowledge of what was claimed to be part of this purchase money transaction. But the court rightfully recognized that Article 9 doesn't have special collateral rules for purchase money security interests. In fact, identifying pieces of equipment by the word equipment is sufficient under Article 9, and that it is expected by the code, the courts, and commentators that interested parties will conduct further inquiry to learn the specifics of the transaction. So this is something where the courts are on board. They do expect interested parties to look beyond the public record. It's also important to understand from a searching perspective that the definition of financing statement means an initial financing statement and all related records associated with that financing statement. So it's not just the initial financing statement, it is all amendments, information statements, filing officer statements, and things like that. And it's also important for a searcher to understand that the record, when they're looking at records and looking at amendments, that every record that gets filed always adds to the record. It never deletes anything from the public record. It doesn't delete anything from the index. Even an amendment to delete a debtor name does not delete the name from the index or from the record. All it does is add another record that the searcher must examine as they're determining what really is in the full state of affairs of that related to that financing statement. So these are some of the basic concepts. There's a certain amount of risk inherent in this process because it's interpreting searches is a human process. And one of the other things that Article 9 does with respect to the filing system and the search process is allocate risk. There is a certain amount of risk in this system that cannot be eliminated, but it can be managed and it can be allocated to the party best able to bear it. And the way Article 9 does this is initially it puts the burden on the filer to get it right. The filer has to file a sufficient financing statement. It has to be authorized. It has to be filed in the correct location. Once the filer does this, the filer is perfected. Even if the filing office screws up somehow and doesn't get it right, they misindex it or their search logic is defective or there's some other reason like this. Once the filer gets it right, they're perfected, which means that at that point, the burden shifts to the searching party to find all the relevant records. So they have this broad general risk. The searcher bears the risk of the indexing errors and search logic performance and things like that. And that means that the searcher isn't able to conduct the razor-sharp search on just an exact debtor name, for example, because they're going to bear the risk that a record that's been misindexed or is somehow otherwise effective doesn't exactly match that name. So what we really have is a system where the searcher has this broad general risk and has to beware. It's a searcher beware type of system. And this means that searchers have to be very careful and they have to cast a broad net as they conduct a diligent search. But in addition to conducting the search designed to disclose all the relevant records, the searcher also has to correctly interpret them, and that means determining the effectiveness of the records that are returned on a search. So I want to talk for just a moment here about what goes into determining the effectiveness of UCC records. Well, it can be expressed in a simple equation. The sufficiency of the record plus the authority of the filer equals effectiveness. A record can be sufficient. It can correctly provide the debtor name, the secured party name, and indication of the collateral. But if it wasn't authorized to be filed, it's not effective. And the corollary to this equation is that filed does not equal effective. It means that just because a record's been filed, that doesn't mean it's going to be effective. The filing office is a repository, and it's a neutral repository. The filing office collects this information and makes it available to the public, but it's the interested parties that have to determine what it means. Now, when it comes to determining authority to file a record, it's important to understand that the authority is established by law other than Article 9. Article 9 doesn't determine whether a party was authorized in any particular situation. That's typically done under the state's law of agency. So it's not something found in Article 9, and as a result, it's not something that's reflected on the UCC records. UCC records simply cannot establish a filer's authority. It's not there. So it's established by the courts outside of the filing system. And when it comes to establishing authority, the filing office doesn't play any role in establishing authority or the effectiveness of records. In fact, I'd argue that absent non-uniform amendments to deal with bogus UCC records, the filing office has no power whatsoever to make a record effective or ineffective. All it can do is make it hidden or retrievable. So the filing office doesn't determine authority. Again, the mere fact that they accept something and file it and index it does not indicate that it's effective. So really, the only way to establish authority is to conduct further inquiry of the parties involved to determine whether it was authorized by the party that would have had to authorize it under Article 9. And that means ultimately that searchers are not entitled to rely on the public record to determine authority. In fact, it simply cannot be done. UCC records are not required to indicate the filer's authority, and they can't possibly do it. There's no way for a UCC record to establish that authority. So filers have to look beyond the public record. Now let's move on and talk about the elements required for a diligent search. First of all, a diligent search, a search that's designed to be reliable, has to be conducted on all the relevant debtor names. And I'll explain that a little bit more in a minute. It has to be conducted in the right locations. It doesn't do any good to look in the wrong locations for active and effective UCC interests. The searcher, in order to conduct a diligent search, has to recognize the limits of the different types of search logic that are available to the searcher, and there are oftentimes multiple options. And we'll begin with the names that have to be searched. First of all, obviously you have to search the debtor's correct name under Article 9 to conduct a diligent search. And the name that has to be searched is going to be based on the type of debtor for the most part, in a couple of cases the type of, or the status of the collateral. But if the debtor is a registered organization, the name that has to be searched, of course, is the name found stated to be the name of the registered organization on the public organic record. If the collateral is being administered by decedent's personal representative, the name that needs to be searched is the name of the decedent. This is essentially what used to be called several years ago the decedent's estate. If the collateral is held in a trust that is not a registered organization, a search must be conducted on either the name of the trust, if the organic record of the trust specifies a name, or if no name is specified, the name of the settlor or testator. Sometimes some people want to search on the trustee as well. That may or may not be a good idea. It depends on the circumstances involved. If the debtor is an individual, the starting point for the name to be searched is always going to be the driver's license. If the debtor doesn't have a driver's license but has a state-issued ID, that would also be the alternative starting point. But name variations are important as well because of some inherent limitations to the use of a driver's license as the source of a debtor name. And for any other organization, the searcher should conduct due diligence and identify any potentially correct names for the organization, and then search on any names that could be correct for the entity. But searching on the debtor's correct name alone may not be sufficient to identify all the security interests that are out there. One example of that is if the debtor has ever changed its name. Under Section 9507C, if a debtor has ever changed its name in such a way that it renders a filed financing statement seriously misleading, that financing statement will remain effective to perfect a security interest in collateral acquired by the debtor before and within 4 months after that name change. So, the secured party, by the way, is under no obligation to amend the financing statement. If they don't, they're going to risk becoming unperfected in after acquired collateral, that acquired more than 4 months after the debtor name change. But if they just if they don't file that amendment, they're still going to be perfected in the existing collateral, and that can come back to haunt a searcher if they didn't look under that old name. So the effect of 9507C is that financing statements filed under the former name of a debtor may still be effective, and that means they need to be searched. So part of a diligent search is always going to require an inquiry into the name history of the debtor, and then a search under any prior names under which records could be filed. But it's not just a change of the name that could be an issue. If the debtor has ever been involved in a merger or acquired other companies, then under section, and what will happen, let me back up a second. What will happen in that type of situation is that the debtor may find itself bound by a security agreement entered into by the merged or acquired entity. And if that happens, then the financing statement filed under the name of that merged or acquired entity will remain effective for collateral acquired by the debtor before, or acquired by the original debtor before and within 4 months after the new debtor became bound. So again, just like a debtor name change, the financing statements may be left out there under the names of these merged or acquired entities, some of which may not even exist any longer. And they can be out there for many years. The secured party is under no obligation to amend them. The risk of doing that is that they'll lose perfection in after acquired collateral. But they could be out there and they could pose a risk for the searcher that isn't aware of the existence of these records. So it is important to search, not just under the current name, but also under former names of the debtor, if applicable, and also under the names of merged or acquired debtors. Now, once the names that need to be searched have all been identified, the next step is to determine where to conduct the search. Determining the search location is really requires determining the filing location for the records. And to determine where records might be filed, requires looking into or making a determination as to what law governs perfection and priority. And to do that, it's necessary to take a look at the code. So what, as far as perfection and priority go, determining the governing law is going to be the law of the jurisdiction where either the debtor or the collateral are located, depending on the circumstances, and I'll explain that in a little more detail in a moment. Once the location of the debtor or collateral are determined, as the case may be, then it's necessary to determine what the filing office is within that particular jurisdiction. Now, determining the location of a debtor or the collateral isn't always an intuitive matter, so it's important to know how to go about this properly. If the collateral consists of personal property of the type that frequently covered in the most common types of collateral that are covered under Article 9, things like accounts and inventory and equipment and goods and all that, the first step is to determine the governing law, and that's going to be the law of the debtor's location that's going to cover perfection and priority. At that point, it's necessary to determine the location of the debtor. The location of the debtor is determined under Section 9307. This has the rules for the different types of debtors as to where they're located. And as I said, it's not always intuitive. Then once that jurisdiction is determined, then it's necessary to determine the filing office within the state. That requires looking to Section 9501. In the case of things like equipment and inventory and so forth, the applicable provision is Section 9501A2. That's typically going to point somebody to the central filing office of the state where the debtor is located. A word of warning, if the debtor has relocated from one state to the other within the past year, it's necessary to also look in the former jurisdiction to be sure. And so once the jurisdiction is identified and the filing office is identified, then the search should be conducted in that filing office. When it comes to the location of the debtor, Section 9307 has some specific rules for that. If the debtor is a registered organization under state law, then the debtor is located in the state where it was formed or organized. This can be counterintuitive because you can have an organization, for example, that's formed in California, formed in Delaware, but its headquarters are in California, all of its personnel are in California, all of its assets are in California. In fact, nobody from that company has ever set foot in the state of Delaware. Nevertheless, Delaware would be the place to search because Delaware law is going to govern perfection and priority because that's where the entity was formed or organized. So, for a registered organization looking for things like equipment and inventory and accounts, the place to search would be the 9501A2 office of the state where the debtor is located. That's typically going to be the Central Filing Office, Secretary of State, Department of Licensing, Department of Financial Institutions. It varies from state to state, but in most cases it's the Secretary of State. For other types of organizations, under 9307, they are located where at their place of business, or if they have more than one place of business, they're located at their chief executive office. So you have to look at where, essentially, what's their primary office, where are they located, to determine the state in which they are located and therefore the state in which to search. If the debtor is an individual is located at his or her principal residence. So a person can only have one principal residence, but it may not always be clear. I happen to live in Minnesota where it gets kind of cold during the winter, and there's a lot of Minnesotans that go south to Arizona or Alabama or anywhere but that doesn't have snow on the ground. And some of these are sole proprietorships that want to work year-round, so they might work in Minnesota during the summer, they might work in Arizona during the winter. The proprietor might have a home in each location, cars registered in one, resident taxes in another. I mean, where are they located? Well, I don't know. It could be one or the other, and ultimately a court is going to decide. So if there's a question about that, it might be necessary to search both locations just to be on the safe side. So in any event, look to the debtor's principal residence, and also be aware that this is not necessarily the same state that issued the debtor's driver's license. People move and they don't change their driver's licenses sometimes. It's the state of residence, of principal residence, not the state that issued the driver's license. And then there are special rules for other types of debtors, foreign air carriers and things like that. I'm not going to go into them in this presentation, but be aware that they do exist in Section 9307. Now, I've covered the rules pretty much for most types of personal property collateral where the governing law will be the location of the debtor. But for certain types of goods, the filing location and therefore the search location will be the location of the collateral. And this occurs primarily with real estate related goods. And when you have goods that are related to real estate, which are going to fall into three categories: fixtures, timber to be cut, and minerals to be extracted, then the governing law determination is a bit different because it's the law of the jurisdiction where the goods are located under Article 9. So for fixtures, it's the law of the jurisdiction where the goods will be located. Same thing for growing or timber to be cut, and in the case of a mine or well, it's going to be the physical location, the mine or the wellhead. So the jurisdiction where the goods are located will govern perfection and priority, and therefore it's necessary to take a look at 9501 again for that state to determine the filing office within the state. It's 9501A1 that's going to determine that location. Typically, that's going to be the office where a mortgage would be recorded on the related real property, so in the real estate records. There are a couple of traps for filing in the real estate records, however. One of them has to do when the debtor is a transmitting utility. The filing office for financing statements when the debtor is a transmitting utility, there's a special rule in Section 9501 for this. But most states designate the same state as the central filing, or the same office as the central filing office. So it'll be the Secretary of State in most cases. The only real exception to that would be, I think, Oklahoma. In Oklahoma, the central filing office for UCCs is the Oklahoma County Clerk, but transmitting utility UCCs, if they indicate the debtor is a transmitting utility, they're filed in the Office of the Secretary of State. Now, the trap with transmitting utilities when it comes to fixture filings is that Article 9 says that a record filed in the 9501B office for transmitting utilities, if it indicates it covers fixtures, it will also be a fixture filing. So it can be a fixture filing in addition to covering other collateral. The trap for the searcher is, again, governing law. Remember that under governing law, a financing statement filed as a fixture filing is filed in the location of the collateral, in other words, of the fixtures. So if you have a transmitting utility that's formed in Delaware, obviously Delaware is going to be the place to file to cover accounts and inventory and equipment. But if it has fixtures scattered in several states, it would be necessary to search the central filing office of each of those states to find any fixture filings against that transmitting utility, not just the state where it's located. Also, there are some non-uniform state provisions related to filing location when it comes to fixture filings and other types of records. Georgia, most records are filed locally. However, they are searched centrally. So there is a central searchable index in Georgia. Same thing in Louisiana. They file through the parishes, but they're searched centrally. Possible exception in Georgia is that there's a non-uniform provision in Georgia that says growing crops are treated pretty much the same way as a fixture filing, so they have to be filed in the real estate records if the collateral consists of growing crops. Louisiana has some special non-uniform filing location rules. For example, fixture filings in Louisiana are not filed in the real estate records. They are filed in the normal central UCC index. They're filed at the parish level, but they all go into the central index and are centrally searched. There's no real estate fixture filings. Also, Louisiana has some non-uniform search locations for certain types of collateral, including motor vehicles, boats, and boat motors. These might be filed with the Department of Public Safety or the Department of Natural Resources. So always pay close attention to the filing location or the filing office locations in Louisiana to determine where to search depending on the collateral. There's one other thing I want to cover, or a couple other things I want to cover about determining search location. The scope of the Uniform Commercial Code includes agricultural liens. Agricultural liens are different from a security interest in farm products. A security interest in farm products is a normal, old, run-of-the-mill security interest. Debtor grants a voluntary, a consensual interest in the farm products to a lender or other party to secure payment or performance of an obligation. An agricultural lien, however, is a different animal. It is a statutory lien. It's an adverse lien. It arises by operation of law rather than consent of the debtor. Agricultural liens do fall within the scope of the UCC, and that means that the claimant of an agricultural lien has to file a UCC financing statement in compliance with Article 9. The issue with the agricultural lien, however, is that the location of the collateral or the location of the farm products, not the location of the debtor, determines where to search. With a security interest in farm products, it's the location of the debtor. With an agricultural lien, it's the location of the collateral or the farm products. So the issue here is that if a person engaged in agriculture or in farming operations has assets in more than one state, it may be necessary to search in more than one state. So if you've got a farmer who's physically located and the farmer's principal residence is in Minnesota, yet maybe they farm some land in Iowa or have a feedlot there as well. There's all sorts of issues that can pop up there. In that case, it may be necessary to search at both the Secretary of State of Minnesota and the Secretary of State of Iowa to find all of the security interests and agricultural liens in those farm products that are on both sides of the border. Another issue is that UCC searches often include related types of searches such as federal tax liens, state tax liens, and other types of statutory liens. These don't fall within the scope of Article 9, but for convenience, many states commingle these statutory liens within the Article 9 filing system. The issue here is that just because a state commingles federal tax liens with UCC, that doesn't mean that that state is the proper filing location for a federal tax lien on a particular debtor. The rules for the filing location of a federal tax lien are different than for a UCC financing statement, and as a result, it may be a different state where the tax lien needs to be filed. And so even though a particular state commingles tax liens and UCC, it may be necessary to search in more than one location to get both. So the search location for these types of records is determined by statute, not by other statute, not by Article 9. Now I want to move on and talk about the search logic involved. Search logic is very important when conducting searches. There are multiple kinds of search logic that are available, and depending on the purpose of the search, one may be better than another. One type of search logic is the filing office's standard search logic. Most filing offices use a search logic that's very precise. It provides exact matches and only exact matches after the filing office has provided or has applied its standard search logic. The search logic does not allow much through other than an exact search, although in most states it will compensate somewhat for minor deviations in punctuation, spacing, ending noise words, and the presence of a leading "the" in the name. But other types of things, spelling errors and stuff like that, are certainly not going to be picked up. And there are plenty of states that have even more precise search logic than that. They may not disregard all punctuation. They may not disregard all spacing deviations. This type of search logic is best used for two purposes. One is to conduct a search to reflect after filing. Because it's so narrow, it will be more telling as to exactly whether the record was indexed and if it was indexed correctly. It's also required to be used to determine if a non-compliant debtor name is still good enough under Article 9 to allow the record not to be seriously misleading. In other words, if a financing statement provides an incorrect or insufficient name of the debtor, if a search of the filing office records using the jurisdiction standard search logic on the correct name of the debtor would find that record, the insufficient name does not render the financing statement seriously misleading. But again, the search logic is so narrow that it will not pick up most deviations. For this reason, by the way, it has limited application for due diligence searches, because if you're going to be making a decision based upon the results of the search, you want a broader net out there. You want to pick up name variations that the standard search logic wouldn't get. And in fact, especially if you're picking up other things like tax liens, they don't have to. The IRS and state authorities don't have to play by the Article 9 rules just because the records are commingled in the UCC index. The other alternative is name variation search logic. This can be available as unofficial state search logic that they make available as a convenience to their website. There's also third-party systems that offer name variation search logic. These are designed to pick up a wider range of name variations, and this is the type of search logic that is best used on a due diligence search because it'll pick up many indexing errors and name variations that could potentially still be effective and pose some risk for the transaction, but wouldn't be picked up on a standard search. So name variation search is generally the way to go when conducting a due diligence search where people have to rely on the results for decisional purposes. Now, one word of caution about the name variation search logic. In using the state unofficial search logic, this is oftentimes very tempting because it's there. Oftentimes it's available for free. People can go in there and sometimes find records very easily. And this is all fine, at least for informational purposes. But for reliance purposes, it does carry some risks because state unofficial search logic generally is not well documented. The only way to learn it in many cases is through trial and error. And trial and error is not a good way to conduct a search on which people need to rely. Remember, it's not merely finding records on a search doesn't mean that it's a reliable search. It's not the records you find that will pose a threat, that will pose a risk. It's the ones that are missed. And in order to reliably use a state's unofficial search logic, it's generally necessary to know not only how the search logic works in all circumstances and how it treats punctuation and spacing and the whole works, but also what the state's historical indexing practices have been. So the unofficial search logic is good for informational purposes, but for reliance purposes, not so much. Now, once the search has been conducted and the results come back, that's not the end of the game for the searcher. That's actually the start. That's an important part of it. The search has to be conducted so as to produce the good results, but the searcher also has to interpret the results, and they have to exercise reasonable diligence in interpreting the results. So I want to go through and explain what's really required to correctly interpret a UCC search. First of all, it is critical to get copies of all the disclosed records, and the reason is that the courts will hold that a searcher has knowledge of the full contents of all the disclosed records, not just what appears in the summary. And summary listings provided by a filing office simply do not provide the necessary details of the transaction. In fact, they frequently only list some of the parties and not all of the parties involved. They may or may not provide some of the indication of the collateral, and as a result, they're of limited utility. They're good as an index, but not for detail. And it's important to understand that deep within the filed records, there may be critical information that the searcher needs to know. That it'll put them on inquiry notice. A record can contain red flags that would indicate it was a fraudulent record or that it was filed without authority. There's all sorts of things that can be identified by a review of the full record, and not just relying on a summary of the search results. So the best practice, always obtain and review copies of all the filed records. Now, when the results come back, there's going to be certain information that's provided by the filing office related to the record that can be helpful for the searcher to identify potential problems with the data or the search itself. One is the file number. There are different types of file numbers out there. Some are sequential, others are intelligent numbers. For example, I can tell from this number that it was the 164th record filed on May 2nd, 2017, because that code is built right into the number. For the hybrid numbers might have just a date and then a sequential number in it, but all of these can be helpful for the searcher to identify a potential flaw in the search, because if they don't match up with the dates that appear in the index for file date and lapse date, that can be an issue. The file date should be the date when the filing office received it and assigned its file number. If the file date doesn't appear to match the date in an intelligent file number, that could indicate that there's a problem, either a wrongful rejection and refiling, or some other filing office error, or some error with the search. And in order to safely rely on the search results, the searcher needs to be able to explain why that discrepancy exists. It's probably something benign, but you can't be sure until you make that determination. The lapse date should be provided, maybe not on the record, that may be shown on the listing, but the lapse date should be reviewed. It should be exactly 5 years from the date the financing statement was filed. If there is a discrepancy between what the lapse date appears to be and what it should be based on the filing date, that can indicate a discrepancy, a filing office error, wrongful rejection at some point with refiling. But it is something that needs to be investigated and explained. In addition to the filing office information that's provided, there's the information that the filer provides as part of the record, and that has to be reviewed as well. The most, I guess, significant is the party information. When reviewing a financing statement and looking at a debtor name, bear in mind that the searcher can see a debtor name that might appear to contain errors, but if it shows up on the search, those errors need to be investigated to, first of all, to determine that it's a correct debtor, and second of all, to determine whether the errors are such that it would render the financing statement ineffective by being seriously misleading. The only way to do that is to compare the name to the source document. I've seen debtor names that appear to have blatant typos in them. when in fact the typo actually appeared in the articles of incorporation, and as a result, the correct name of the debtor for purposes of the financing statement was the name with the typo in it. Debtor address and organization information. From a search interpretation standpoint, it's important to recognize that this information is provided solely for indexing purposes. It is not required for information or for sufficiency purposes. In other words, a financing statement filed without a debtor address, and in New York they still require organization information. If it's filed without address or without organization information, that will not make the record ineffective. There's a slight risk of subordination if somebody reasonably relied on the absence of that information, or if it's provided and it's incorrect. But the contents of the debtor address and organization boxes will not make a record ineffective. The secured party name. It's important to understand that the secured party name is not held to the same standard as a debtor name. And that's because the secured party name is not used for retrieval of the record. So just about anything goes. It can have typos. It can it can be a DBA, which doesn't work for a debtor name. It can indicate capacity or contain descriptive information. It can even be a representative of the debtor, and it doesn't even have to, or of the secured party, I should say, and it doesn't even have to indicate that. So as a result, the secured party name, just about anything goes for that, and searchers need to be careful not to disregard a record based on the secured party name. Also, secured party address. Secured party address, like the debtor address, is not required for sufficiency or effectiveness of the financing statement. It is only required to avoid rejection. An incorrect or omitted secured party address that sneaks through the indexing process without being rejected will be effective. So searchers need to be aware of that and not put too much reliance on secured party address. In fact, the best practice is, when you're interpreting the party information, if the debtor name matches the subject of the search, then the record should be treated as effective. It shouldn't be disregarded as effective, in other words, unless the searcher conducts further inquiry to verify that it either isn't the debtor they're looking for, or that the record is ineffective due to the information that was provided. When it comes to collateral and interpreting the effect of collateral, all the financing statement has to do is reasonably identify the collateral. It does not have to identify it generally in any particular way. In fact, the code is rather generous to the filer for how they identify the collateral. It can be by a specific description. John Deere Model 350, serial number 12345. It can be by a less general or a less specific description. John Deere bulldozer, bulldozer Model 350, John Deere Model 350. It could be by type or category, such as equipment. Perhaps inventory would cover that. And it can even be by a super generic description, such as all assets or all personal property of the debtor. So the collateral can be described any number of different ways, which means that interpreting it, the searcher has to read that collateral very broadly and give the benefit of the doubt to the filer. Serial or model numbers, searchers have to be very careful about relying on serial and model numbers, because errors in these numbers generally are not going to render the financing statement seriously misleading. There's plenty of case law out there on that. Oftentimes you'll see collateral incorporated by reference. It'll say, see attached Exhibit A for collateral, or words to that effect. Sometimes the exhibit or schedule that's referenced isn't there. And if the fault of it, if it was left off by the filer, guess what? Filer hasn't provided any collateral and the financing statement is seriously misleading and not effective. But from a searching perspective, searchers can't just jump to that conclusion, because if it was a result of a filing office error, that's an indexing error, and the risk of that error falls on the searcher. Searchers have no way of knowing where that got lost along the way just from the record itself. And there are plenty of examples out there where this has happened. I've talked to filing offices that found an attachment in a drawer a year after they'd indexed the record without the attachment. Just last year, the Pennsylvania Department of State was mistakenly discarding attachments submitted on records that were filed over the counter and through the mail and courier delivery. They did that for over a month before it was caught. Before you panic, by the way, most of those have been fixed now through work with the filers. But it is a very real risk in assuming that the lack of an attachment is the fault of the filer. It could very well be the fault of the filing office, and it is important that the searcher go ahead and determine where that happened. That means conducting further inquiry. So the best practice is give the filer the benefit of the doubt until after conducting further inquiry of the parties involved to determine if any discrepancy it created a problem, or to determine specifically what's covered, especially when they've described the collateral by type or category. There are certain indications on a financing statement. These include things like duration indications. These such as checking that the debtor is a transmitting utility, or that the record is filed with a manufactured home or public finance transaction. These, in most states, will have an effect on the lapse date, and it's important to verify that the lapse date ties to the indication on the record. So in most states, if it's a public finance or manufactured home transaction, it'll be a 30-year lapse date rather than a 5-year lapse date. But bear in mind, there's a lot of non-uniform adoptions of 9515 in regard to public finance and manufactured home transactions. And so if these boxes are checked, you might have to check the statute in the particular state to see if the lapse date has been set correctly. There are check boxes related to the status of the collateral that say it's held in the trust or being administered by a decedent's personal representative. These are debtor name requirements to check those boxes, and technically required for sufficiency of the record. So these are something to be aware of, and that should indicate to a searcher the nature of the collateral and how it is being held. There are alternative designations that can be indicated on a financing statement: agricultural lien, non-UCC, buyer-seller, and so forth, consignor, consignee. These are optional. These have no effect whatsoever on the ability of the financing statement to perfect a security interest if a court decides that it was a security interest. So you cannot rely on these indications to determine that there's no security interest involved. Only through additional research beyond the public record can that be determined. Now, we've taken a look at the filing office information and the information provided by a filer on the financing statement. Now I want to talk about what's involved in interpreting the effect of amendments, because there are some amendments that, despite their title, do not do what it appears they're supposed to do, and also are sometimes assumed to have more effect than they really do. So let's go through these, and especially those that can create potential traps for the unwary searcher. And the first is the termination statement. And this is one that is oftentimes misinterpreted in the search process. In fact, we sometimes get attorneys and paralegals that will tell us, conduct this search but don't include any terminated financing statements in the results. And I think the thought is that, well, if it's terminated, it's not effective. and therefore why should I waste the time and spend the money to review it? Well, the answer to that is let's look at it in a bit more detail and then and revisit it in just a minute. The purpose of a termination statement is to indicate that the financing statement to which it relates is no longer effective. Some interpretive considerations for a termination statement. One, a termination statement is just a form of amendment. That's how the filing office treats it. When a termination comes in, they index it so it can be retrieved with the record. I mean, it's used to indicate that the record is no longer effective, but when it comes to its actual effect, it depends on whether it was authorized. If it wasn't authorized by the secured party of record, then the termination statement is simply not effective. An unauthorized termination statement is not effective. And if it's not effective, it's still going to show up on a search, and the person conducting the search is going to look at it, and the financing statement will show filed here, and then it'll show terminated here. But if it's not authorized, that termination statement isn't effective, and the financing statement remains effective. In addition, if there are multiple secured parties of record, it's important to understand that a termination statement filed by one secured party of record has no effect on the financing statement with respect to other secured parties of record, unless, of course, those other secured parties of record have authorized the filer to file on their behalf. But that authorization isn't required to be indicated on the face of the public record. As a result, it can be a record filed by one when there are multiple secured parties, may be effective, but only with respect to the party that filed it. So an effectively terminated record would still remain effective if there are multiple secured parties. The only way to really figure this out is to conduct further inquiry. The searcher cannot assume that just because a termination statement has been filed that the record is not effective. And there is case law out there to support this. Probably the leading case is called Reg East. What happened here was that a bank held a blanket security interest in the debtor's assets. At some point, a termination statement was filed, but it wasn't filed by the bank. In fact, the court, I don't think, ever figured out precisely who filed it and didn't go into that, but it was clear that it was not authorized by the bank. Well, another secured party came along, saw that the first financing statement had been filed and that it had been terminated, and relying on that termination without making any further inquiry, the second secured party filed its own financing statement and incurred an obligation, or the debtor incurred an obligation to that second secured party. Well, when the debtor defaulted, guess what? The first secured party was perfected and had priority over the second secured party because they didn't authorize that termination. So bottom line is that termination statement wasn't effective, and the second secured party took subject to the financing statement filed by the first secured party. So it's necessary to verify, as part of further research beyond the public record, that each secured party did in fact authorize the termination statement. Continuation statements can even create a little risk for searchers. The purpose of a continuation statement is twofold, and these are separate and distinct purposes. One is to extend the effectiveness of the record for an additional 5-year period. The other is to keep the record active in the searchable index for an additional 5 years. The filing office is only concerned with the second of those two, keeping the record active. The filing office is not concerned about the effectiveness of the record. Now, when you see a continuation statement on a search, which happens frequently, there's some things to bear in mind when interpreting what it means. The mere fact that it's in the index doesn't mean that the record is effective. A continuation statement filed on an ineffective record isn't going to make it effective. It's just going to keep it retrievable for an additional 5-year period. A continuation statement filed more than 6 months before the lapse date or any time after the lapse date is not effective as a matter of law, even if the filing office accepts it and indexes it. And a continuation statement filed after the lapse date is going to leave the security interest unperfected, even if the filing office indexes it. And there have been cases where filing offices mistakenly accept continuation statements. The Florida Secured Transactions Registry did that for a period of years. They were accepting them late and resetting the lapse date, and everybody assumed that because it was filed and the lapse date was reset that the record was effective. But by operational law, those would have ceased to be effective when the continuation was not timely filed. So, thing to bear in mind here, a continuation statement showing it was filed after the lapse date could be an issue on the search, and but it could also mean that a wrongfully rejected continuation was refiled after the lapse date and was treated as effective because a wrongfully rejected record is nevertheless effective. Some filing offices don't have the ability to backdate. So further investigation is required in these situations to determine whether a late filed continuation is effective or not. UCC 3 assignments. The purpose of an assignment is not to assign the security interest. It's actually to assign some or all of the secured party's right to amend the financing statement. So when interpreting the effect of an assignment, it's important to remember that all it does is assign the right to amend the initial financing statement. It's not assigning the security interest. It's not even required, as a matter of fact, even if the security interest is assigned. All an assignment really does is add a secured party of record. It does not replace a secured party of record. It doesn't delete the assignor from the record. There's still a secured party of record. All it does is add the assignee as a secured party of record. So when interpreting these, the best practice is just to treat it the same as an amendment to add a secured party. They have the same effect. Both assignors and assignees should be treated as secured parties of record, and that means they should get notices to which they're entitled and so forth. In fact, there is a case out there where a searcher found itself facing a substantial loss because it misinterpreted what an assignment meant. This was a case called Rentenbach Constructors. Rentenbach had granted its bank a blanket security interest in all its assets, and the bank filed a financing statement. A couple years later, a factoring company came along and entered into an agreement with the debtor to factor its accounts, and it went to the bank, and the bank filed a partial assignment of accounts receivable to the factoring company. The factoring company then filed its own financing statement, and everything went along well for about a year. And then Factor 2 stepped into the picture. Factor 2 paid off Factor 1 and had Factor 1 terminate its financing statement, and then Factor 2 filed its own financing statement and proceeded to factor the accounts for the debtor. The debtor defaulted, and as a result, the bank and Factor 2 wound up in court going after the assets, the only asset of which was about $76,000 in accounts receivable. And Factor 2 said, well, the bank assigned its security interest in accounts receivable. As a result, we're entitled to first priority in those funds. The bank pointed out, no, we didn't assign the security interest. We filed an assignment, but we did not assign the security interest because the security interest wasn't assigned. It still remains with us, and we're perfected by our financing statement. And the court agreed with the bank. The lesson here is that Factor 2 could have protected itself. When it conducted a search and saw Factor 1's financing statement and the bank's financing statement, it could have contacted the bank to find out what the bank's claim was, but instead it relied on the public record, and it suffered a substantial loss as a result. A couple other search issues to quickly go over. If an amendment is filed after a termination, this shows up on searches all the time. This can mean a couple of things. For one thing, an amendment filed after a termination cannot revive the effectiveness of an effectively terminated financing statement. But it may indicate either A, that the secured party was unaware of an unauthorized termination statement, or it could indicate that the secured party just simply got its wires crossed and continued or amended an otherwise terminated record. The only way to know for sure is through further inquiry. A UCC 5 information statement, this record has no effect on the financing statement. It has no legal effect, but it will alert a searcher to problems with the record, or that the record, the effectiveness of the record is somewhat in dispute. Searchers better pay attention to what's in there and conduct further inquiry. Also, a filing officer statement. This will alert the searcher to any changes that were made to the record by the filing office due to errors. Close attention and conduct further inquiry if necessary to determine what that all means. And in some cases, there are records that are filed that are not required by Article 9, and this might be something like a subordination agreement or separation agreement, or somebody filing a notice of non-interest. These sometimes get filed in the UCC records. They're not necessary, but they still have to be looked at, because it is possible that they would contain information that would alert the searcher to something that they should inquire further into. So if it's in the record, it has to be reviewed. That's what the bottom line is. So, summary of the best practices for conducting UCC searches. Number one, it's necessary in conducting a reliable search to search all the necessary debtor names, conduct a search in all the correct locations, make sure you are using the right search logic for the job, and review copies of all the disclosed records. When interpreting the results, reconcile the file numbers and file dates with lapse dates. Review the sufficiency of the record contents, but be sure to give the benefit of the doubt to the filer until after having conducted further inquiry. Make sure to understand the effect of every amendment, and above all, be sure to conduct further research beyond the public record whenever necessary to resolve any ambiguities.